Today's topic is persons capable of making wills under Indian Succession Act of 1920. Now, as the definition of will states, it is a document which is being made by the testator for the purpose of distribution of his property after the death or after his death. The will comes into effect after the death of the testator. Now, who are the people who are entitled for making of such kind of wills? People who have soundness of mind, persons who are not minors, a deaf, dumb or a blind person, insane persons. Now, to go one by one, a person who is of sound mind. Accordingly, a person who is of soundness of mind and who is capable of understanding what is happening in his surroundings or around his surroundings, such a kind of a person is a person who is entitled to make a will. And also, a person who knows what are the repercussions with regard to execution of such a kind of a testamentary documentation called as a will, where the property goes according to testamentary succession. Now, a minor cannot make a will. A minor is not a qualified person for making of a will. For making a will, a person must and should have attained the age of majority under the Indian Majority Act. A person should be 18 years of age, otherwise 21 years of age under circumstances. Now, a person who has attained the age of majority is a qualified person for making a document, that is testamentary succession of his property and devolving the property by way of will. A deaf, dumb or a blind person. Now, deaf person, a dumb person, a blind person. A deaf person is a person who cannot hear, a dumb person is a person who cannot speak, and a blind person is a person who cannot see. Now, this is a challenge with regard to execution of will of such kind of or category of people. Now, there is no hard and fast law or rule which states that under Indian Succession Act that these people are not qualified for making of the document will or a testamentary succession for their property. A deaf person, a dumb person, a blind person are perfectly qualified for making of a will. Now, let us talk about a deaf person. A person, he cannot hear or she cannot hear, but always they could write the will and they could attest the will. As well as the dumb person also, the same circumstances, the same conception where the person can make a will by way of writing or writing down and attesting. About a blind person, can give his intentions or make his intentions very clear to a scribe who is being appointed by him and writing down what he exactly is wanting to or intending to devolve by way of testamentary succession after his death. So, a deaf, dumb and blind person are qualified for making of will. Now, about an insane person. An insane person is equivalent to, not equivalent to, we can say that they are unsound person. Now, unsoundness is of two types, that is continuous and continual. Continuous means a person is continuously unsound. Example, retarded persons. Now, continually in breaks, that is in legal terminologies we call it as lucid period, where a person is coming in soundness of mind and again going back in unsoundness of mind after a stipulated period of time. Now, in this position, this insane person or such category of insane persons can make a will in lucid periods, that is when they are coming in soundness of mind. Henceforth, these category of people, that is deaf, dumb, blind, insane people are qualified people for execution of a will under Indian Succession Act. Now, the testamentary succession no doubt is being done with regarding to the property of an individual who is owning the property and presently in possession of the property. There are other aspects which could be made a testamentary succession of in a will, like appointing of a testamentary guardian, which is spoken under section 60 of the Indian Succession Act. Now, a testamentary guardian is a guardian who has been appointed through the will by the testator or the maker of the will. Now, the testamentary guardian is being given duties for the purpose of acting as a testamentary guardian. Now, a testamentary guardian, once has been appointed, there is no compulsory or compulsion on a person to accept him to be as a testamentary guardian. He could also renounce or give up or not accept. Now, under such circumstances, he doesn't remain to be as a testamentary guardian, and section 60 of Indian Succession Act does not apply. But if at all he or she who has been appointed as a testamentary guardian does accept, then they have to comply with the conditions, duties which has been provided to them or which has been written down to them in the will. Now, whatever has been written down in the will has to be obeyed as the words next to God. That is the importance of the will, and that is the purpose of execution of will, and that is why the will comes into effect after the death of the testator. Now, next we shall go on to the execution of privilege as well as unprivileged